Good morning. Thank you for joining us at such an early hour. I didn't think there were two 8 o'clocks in the day, I have to confess. It was a bit of a new experience for me. So we're going to talk about Brexit. This was a session that Peter and I proposed some months ago, and at the time we said rather jokingly to Stuart, wouldn't it be interesting if Brexit happens, we could have a session on it, what do you think? Not at that point seriously thinking that it would ever happen. So this has turned out to be it's a turn up for the books. What we're going to do is, some of you will have thought deeply about Brexit and the implications of Brexit, some of you may not. So the session will be split into two parts. Peter Church, counsel in my team, will set the scene, setting out some of the legal options and some of the legal implications of Brexit, the process, what post-Brexit might look like. And then we'll hear from a couple of panellists who've got what seemed to Stuart and I particularly relevant experience. So the first is Finn Merstad, who's sat next to Peter. So Finn is, although he is the head of digital services at the Norwegian Consumer Council in Oslo, he is here this morning in a personal capacity, having spent 10, 15 years working on behalf of European and Norwegian businesses, the Norwegian government in liaising with the European Commission, the European institutions. His perspective of life right at the edge of the European institutions we thought would be interesting for this group. And then the second speaker, who's not quite here yet, is Rory Munro, who's the head of the UK's negotiating team with the Article 31 Committee and DAPIX. Just in time delivery. He arrived at a perfect moment. So, and then what we hope is we'll hear briefly from Finn and Rory, and then there should be plenty of time for questions. That is the principal aim of today's session. So we're going to start with Peter setting the scene.
Okay, so a couple of points to start with. The first is bias. I personally was much more profoundly affected by the Brexit vote than I had anticipated, and I think that's partly some of the anxiety about the political instability in the UK, but also I think it's a question of identity, and actually looking at the Brexit vote, I think it cuts to my identity as a European citizen, and that's something I think I feel much more strongly about than I had anticipated. So in relation to a lot of the issues we're going to discuss today, there's some subjective judgment about what the future might look like, and I'm very much prepared to admit that my judgment might be clouded, I think, by my own views about Brexit. The next is priority. There are so many issues to consider as part of Brexit: access to the single market, free movement of people, the relationship of the England with Scotland and Northern Ireland going forward, and many other things. And obviously the other EU states have other things to think about as well, so they'll be thinking about the migration crisis. And the point here, I think, is while there are sensible and practical solutions to be reached in relation to many of the issues facing us, I have some concerns about whether or not there will be the time or political capital expended in order to reach them. Certainly someone in the civil service, ex-permanent secretary for the FCA, said this is going to be the biggest administrative and legislative challenge since 1945. I mean, Rory, do you see it as being a fairly big challenge from your side?
Yes.
Good. I'm going.
I mean, yes, it is. Clearly, it's the biggest thing I've ever been faced with in my lengthier than I like to admit civil service career, and as everyone knows, the government campaigned for a Remain vote, and there were repeated statements that there wasn't going to be any contingency planning. It's not strictly speaking true to say that there was none at all, but I think it's also fair to say that the result did surprise many of those at the centre of government, and certainly in terms of working out exactly how to unpick all this. As you'll have heard, there's a new policy unit being set up under Oliver Letwin. It's in the Cabinet Office. It's going to be an expansion, really, of the European and Global Issues Secretariat that operates in the Cabinet Office, and that is still being got up and running. That will have an awful lot of work to do. and that, you know, the new leader of that isn't actually yet in place. So yes, there's a huge amount to do, well, obviously the clock hasn't yet started ticking, but once it does, 2 years isn't a huge amount of time. I mean, 2 years wasn't very long to implement the GDPR. Implement's not quite the right word, but I hope everyone understands what I mean. But certainly now it becomes a little bit more confusing.
And I think the final point to think about is the attitude of the other member states and the EU itself, which are not a homogenous body and who have different views about the UK. I mean, at one extreme, Jean-Claude Juncker suggested that the UK could expect no favours for deserting the EU. At the other end, I think certainly you've seen, for example, Angela Merkel appears to be looking for perhaps a more constructive approach to the EU, the UK exiting the EU. So we'll have a look at what's next. I think we'll think about what data protection laws will apply in the UK, what the position will be for transferring personal data from the EU to the UK, and then maybe very briefly touch on the effect of Brexit on the development of EU's data protection laws. So as a very brief reminder, nothing has happened legally. The referendum was an expression of the democratic will of the British people, but it has no legal effect. The legal effect will take place when the government decides to serve the Article 50 notice on the EU, and that will trigger a 2-year period in which to negotiate and leave the EU. David Cameron has decided not to serve the Article 50 notice before stepping down, and he's left that to the new leader. We have 5 candidates at the moment who are currently contesting the Conservative leadership election. They'll be whittled down to 2 candidates, and those 2 candidates will go out for a vote amongst the grassroots Conservative activists. And I think we're anticipating that we should have a new leader of the Conservative Party on the 9th of September. So I think really until the 9th of September, until we have someone in charge with a mandate to take the UK forward, the position is likely to remain uncertain. You do see some discussion about whether or not there might be some potential here for acceleration, whether or not the Conservative Party might coalesce around a single candidate to appoint them now. Whether or not that's possible, I think, is difficult to say. So what are the options for the future? Well, there are a range of options set out here. Slightly complicated diagram setting out the various different permutations and the implications of each. But it seems to me actually what you've got essentially is a trade between freedom of movement of people and access to the single market. And the UK will, I think, have to think about which it wants going forward, because while there's been a lot of discussion about having access to the single market and being able to stop freedom of movement of people, that strikes me as being potentially optimistic, though who knows. And as part of that, there's been a lot of discussion about the Norway model and the EEA model, and Finn, I wondered if you could just maybe talk about your experience there.
No?
Yeah.
Yep. Okay, hi, thank you. So I'm here in a personal capacity. I'll speak tomorrow in an official capacity on other issues. My background is so the full disclaimer, I used to work on the Norwegian join side more than 10 years ago, heading the youth movement there. For more than 2 years, I was campaigning for Norway to join the EU, which was a completely failure because we're still not a member. And since then, I worked in the European policy unit of the Minister of Foreign Affairs, coordinating European policy, Norwegian European policy. Basically, we were about 5 people with a white paper guiding us, trying to design the lobby strategy for Norway. And then I went on just to do a master's at LSE in European politics. So I have a little bit of a background information on how the EU works. And then I worked 5 years in Brussels on behalf of Norwegian companies lobbying the European Union. And from that experience, I have a few, I thought I'd tell you very briefly a few stories. But just so you know what the EEA agreement is, it was a temporary agreement designed in 1992 to ease membership for Norway and the EFTA members, so Sweden, Finland, Austria. But Norway was the only one who actually needed it because the others became members very quickly. So it was a temporary agreement at the time, which has now survived since 1992. We also have 74 other bilateral agreements with the European Union, which is almost no one is aware of, and that covers the the field of justice and home affairs. It covers so the Dublin agreements, the Prüm agreement, Europol, Schengen. So some people say that Norway is even more integrated in Europe and in the EU than the UK currently, except that we don't have a say. And I think that's that's my main message here today, from a business perspective, from a civil society perspective, and from a government perspective. Not being a member, of course, is a huge disadvantage from an interest perspective. Working for the government, we basically had to rely on getting papers from other countries that were nice enough to us to share documents with us. The only way we could influence formally was through commission consultations, and then it all went into this big black box called the European Parliament and the Council, where Norway has very little formal influence. And Norway basically becomes a lobby nation along the lines of any other company, to be honest. And then when living in Brussels, this became, of course, a huge challenge for global Norwegian companies. Obviously, they benefit from the free trade. They benefit from the single market. I think without that, Norway would have been much more isolated and not as wealthy as it is today. So there's a huge benefit of being a part of the EEA because it gives market access and, of course, free mobility. So from a company perspective, in Norway, we have many international companies. People move freely and they work very easily in Norway. But, of course, from a interest perspective, if you have an interest in Europe, so I was working for large multinational companies, we sort of had to knock on the doors of the European Parliament hoping that a Swedish member of parliament or a Danish member of parliament would see us if they had time. And very often we experienced that we would meet with Czech MEPs or German MEPs, and they would sympathize with our views. We would even have solutions, if this was an area of renewable energy, that would be beneficial for all of Europe. But at the end of the day, they had, let's say, a coal-fired power plant in their constituency, and of course they had to listen to them rather than us. So basically Norway, from my perspective, has become a lobby nation, and it's a bit like in these European Championship days. So the EEA is like being part of the football team, but you're always on the bench. So when you lose, you lose. When the team wins, you win, but you have no way of affecting the game.
I should have said at the start that we're not mentioning the football.
I'm so sorry. Yeah,
It's completely forbidden.
Yeah.
Okay.
So, and yesterday it was about 240 years since the American Brexit. And I don't think we should, and I don't know if we should be inspired by that or not, but at least from a European perspective, I think I would say that EEA model is good for business because we have full harmonization in the sense that there's no insecurity. So from a data protection point of view, as I mentioned from the seats yesterday, we implement all the laws. Some people say we're more Catholic than the Pope when it comes to implementation of laws because we're frequently on the top list of implementation. We have something called the EFTA Surveillance Authority and an EFTA court, which acts like the European Court and which acts like the European Commission. And we have enforcement. And basically, we have just this parallel structure that functions just like the EU, except that we have no influence. I think that's the easiest way of describing it. Of course, there are a lot of details here. And of course, my personal vote would be for the UK to stay in Europe because I see how much influence you can have by being a member. But obviously, that's not an option right now. So I would say EEA is a very good option for business, but you have to increase your lobby budgets.
And the problem with EEA membership is you retain freedom of movement. You've still got to contribute to the EU budget. You've still got to comply with EU laws, but you have no control over the passing of those laws. So, I mean, my view is it's difficult to see EEA membership as being the solution. The other option is, of course, to exit the single market in order to be able to control freedom of movement of people, and the potential economic impact there is obviously uncertain, particularly given that services are such a large portion of the UK's GDP. So what comes next? Who knows? The options are for the new leader to start negotiating with the EU, to have some soft negotiations before pulling the Article 50 trigger. You're looking at me curiously, Richard.
It's a reference to the Daily Mail on your slide.
I'm getting there. So to start to negotiate with the EU before pulling the Article 50 trigger, but certainly the EU said that there will be no negotiations until the Article 50 notice is served. People talk about second thoughts, whether or not we might have a second referendum or a general election. But the point there, I think, is, again, my view is that leaving the EU is going to potentially have negative consequences for the UK, and everyone I talk to thinks that it will have negative consequences for the UK, but that's because I think we all live in a London bubble or a privacy bubble, and there are, I think, many people out there who continue to think that Brexit is going to be fantastic. So my butcher, for example, who tells me that it's going to be great for Britain, Brexit, but I haven't got the guts to ask him why. And then the final option is to serve the Article 50 notice, and that's the point at which the formal withdrawal process starts. So I guess interesting to have views from the audience. Who thinks at the conference next year the UK will have served the Article 50 notice? Who thinks the UK won't? Okay. Any offers about why anyone who thinks the UK won't have served the Article 50 notice? Any offers about why that is?
What do you think about this counterargument challenge, the legal challenge, to saying it has to go before Parliament?
So my understanding of the challenge is that Mishcon Rea or their argument is essentially because the Article 50 notice will in effect revoke the European Communities Act. That's not an action that can be taken by the executive. That needs to be an action that's taken by the legislative. I think it's interesting because you will therefore need to get Parliament to approve the issuing of the Article 50 notice, and certainly the suggestion is actually that the vast majority of those in Parliament don't think that it would be a terribly good idea for the Article 50 notice to be served. So you've got that clash between representative democracy, in which we vote for our representatives and trust in them to do the right thing, and referendum democracy, where we view we follow the expressed will of the people. So it will be interesting to see how Parliament vote in that situation, but I think the problem is that given the result of the referendum, it's going to be extremely difficult for those in Parliament not to allow the Article 50 notice to be served. And I think the risk is that if they were to block the service of the Article 50 notice, then you're going to see more political instability, and it would strike me that you might, at the next general election, see, for example, a very large UKIP contingent being returned in the UK.
So the counter on the legal... So David Panic, QC, has written on this subject. He's the lead counsel for Mishcons on that application. He's a much more eminent constitutional lawyer than I suspect any of us in this room. The counter-argument, though, is also pretty well known. The European Communities Act says within it that all of the rights, powers provided to the member states by European legislation may be exercised by the relevant minister. And one of those rights is Article 50. Article 50 is incorporated into UK law by virtue of the 1972 legislation. So the counter-argument is that there is no conflict. Parliament decided to give executive authority to ministers to exercise all the rights set out in European legislation. That's what Parliament decided in 1972. There is no conflict if a minister then decides to exercise that power. That's the counter-argument.
Would the government go ahead with that potential legal challenge? Would they go ahead and trigger it without...
So I think the problem comes actually when you start to think about replacement, because whatever happens, it seems to me Rory will know much better than me, there is an enormous legislative challenge in replacing what European legislation does to our statute book. And even if you say, well, I'm just going to pass a law that says everything that happened the day before Exit is going to happen afterwards, I paraphrase, you're still going to need to put that through Parliament. I can't see any alternative to that. And at the moment, I'm not sure how that vote's going to go. So that I think may be the challenge. What do you replace the 1972 legislation with, and how do you do it?
One potential is, I was just thinking, just one potential, I was thinking, could they possibly then force a second referendum if the parliamentary vote went against Brexit, rather than saying no Article 50, but second referendum?
One thing that seems to me to be inconceivable is that we don't implement the will of the people absent a second referendum. You know, if we decide not to Brexit, I can't see any way of doing that without a second referendum. That seems to be inconceivable.
If you think, probably a bit cynical, but do you think there's anything that can be read into the fact that when we had the Brexit poll, that the areas was 382 as opposed to the parliamentary constituencies? So you could argue that it would allow MPs to vote as they wanted, because they could say that the areas that they were covered by, they can't say whether it was a yes or no vote for their parliament, their constituency, because it didn't follow the natural boundaries that we expected to.
So I can only speak for the local constituencies that I know best, and I live in Lambeth, which is the outside of Gibraltar, the most pro-EU constituency in the UK. It seems to me very ambitious for any member of Parliament who represents Lambeth to vote in a way inconsistent with that if they want to hang on to their seat. And each member of Parliament will be making a similar kind of assessment on a little micro basis. We'll have time for questions at the end, but Peter, is there anything else that you wanted to pick up on that we haven't covered already?
No.
Okay, right, in that case, open season. Right, Christopher, Mr. Millard. Hold on, there's a microphone coming because you're right at the back.
Thank you very much. Yes, it may well be not ultimately a legal issue, but a political, pragmatic negotiating issue. On the one hand, the European Commission has made it very clear that they want us out as soon as possible. They won't negotiate until we press the trigger. We, however, don't have to press the trigger at any particular time. So there could be an indefinite standoff, and it's a question of who blinks first. I mean, blinking is putting it rather mildly, because it could get all rather unpleasant on both sides. So I think it's quite possible that will depend on who becomes the next leader of the Conservative Party, assuming they're not immediately tipped out at a general election. And we can already see a taste of Theresa May's negotiating position in that she yesterday wouldn't even state that EU workers in the UK would necessarily have a right to remain here, because she's keeping all of her ammunition in reserve, I guess, to go into potentially a very tough negotiating position. And some of that may actually happen, as often happens, behind closed doors, and it won't officially be a negotiation. It'll be a talk about talks, and they can all say, we didn't talk to you till you pressed Article 50, but actually they're talking all the time. So that's why, pragmatically, I think it may well run into next year before Articles 50 is triggered, and it could go on forever.
I don't know if anyone else at the panel has views about, or is prepared to express views about when Article 50 might get served. No?
I mean, my only comment would be there will be a lot of uncertainty in the UK until the issue is resolved, and the EU will probably know that there could be adverse economic consequences for the UK for indefinitely postponing it and in giving businesses effectively no clear view about what the future relationship is between the UK.
Sure, but it'll also be very painful for several other EU member states.
You can see three things potentially bringing an end to an indefinite stall. One is a short and rather unpleasant recession in this country, which might be a reason to look again at the issue. You can see that. The second may be the UK signing a contingent trade deal with another major economy outside of the EU. That would cause some consternation in European capitals. And the third might be a general election. You can see that all of those things might I think there might be a long period of pre-negotiation, but I'm not sure it'll be indefinite. Any other questions? Yes. Mr. Leaton-Gray.
Yeah, morning. This is now sort of not so much wearing my privacy hat. Before I got into this wonderful profession. I've spent my life as a political journalist. This is an admission. It's a bit like being an alcoholic. It's one day at a time. I don't know whether I'm particularly pleased. I'm not a journalist at the moment, or particularly pleased. I would like to be back in there, if you see what I mean. It's a point about the negotiations and the way in which this goes ahead, and actually it also reflects upon some of the things that both the ICO and the Baroness were saying yesterday. It seems to me that there's an interesting presumption that's being made at the moment on both sides that somehow it's almost as if Article 50 has been triggered. It's almost as if we said, right, that's it, we've already started, we're out of the door. The reality is, at the moment, as far as I can see, legally, we are still a full member of the EU. So, during the negotiations on the setting up of the EDPB, we will probably be the least favourite child at the party, but we still have to be invited, because we will have a seat at that table, even after Article 50 is triggered, it seems to me, because the negotiation is about the exit. Up until the moment of the exit, we are a full member of the club. Now, you can either see that very cynically and say, right, we can make life bloody awkward inside the systems of government of the EU and use that almost as a negotiating tactic. I don't think that's particularly likely, but I do think we're perhaps underestimating the degree to which actually we are still involved, and part of that process of Article 50 removal has to be involved in sort of, we're at the table while we negotiate in real terms inside other institutions. And I wondered, what you'd say in terms of sort of, it does seem to me that we are still there, we're at the table, and because of the uncertainty, strangely, that's likely to carry on being quite influential, isn't it?
No, it's an interesting perspective, and clearly, yes, we are until we're full members of the EU, continue to be so, and will continue to be operating as if the GDPR will be taking full effect in the UK, as indeed assuming that we're not out by the 25th of May 2018, then something will have to happen. The GDPR will have full effect here because we will be part of the EU. In terms of the but query, of course, what the new incoming Prime Minister and ministers decide that they want to do in terms of negotiations with the Commission and other member states about whether it really does mean that it takes full effect at that stage. I mean, again, those are all... There's a whole series of Donald Rumsfeld's known unknowns, I think, at the moment. And goodness knows how many unknown unknowns there are. But it's an interesting point you make about having still retaining influence, because, of course, on one reading, we may have very little influence, because it may well be the view of those leading the negotiations and other member states. Well, certainly the Commission might think, well, Bruno will say, whether I'm sure Bruno won't say, but there may be a view from the Commission that, well, actually, what's the point really of continuing with the UK? We know that they're going, particularly once Article 50 has been triggered, and the important thing is to keep the other 27 member states knitted together properly. There will be a question, of course, about alliances and the level of soft power that we continue to retain, and there might be a lot of this surely is going to be dependent on, I suppose, the toxicity with which we're regarded around the negotiating table, and some of that, again, I think it's probably can't be underestimated, going to be to do with the tone that the new government takes in terms of the negotiations. So were we to be looking at, just to pluck a name at random out of the hat, of Prime Minister Farage, I think it's unlikely, then we might have more difficulty than we would with, say, a Prime Minister May. It's really, really very difficult. I take your point. I suppose I've been proceeding in the last couple of weeks from a personally slightly more pessimistic view that we might have less rather than more influence, but certainly there will be opportunities that the civil service and politicians will be doing their best to make the most of in terms of taking that debate forward. Yeah.
Can we ask a question of the audience? Because you raised an interesting point about the GDPR. Let's imagine that we're all still here in 2019. The There's still electricity, there's still gas, those kinds of things. So 2019, what kind of legislation, privacy legislation, will we be living under? So we've probably got a few options. It could be GDPR, could be some form of Data Protection Act, maybe amended, or it could be no legislation at all. Hands up who thinks we're going to have the GDPR in all its glory in 2019. Group of privacy advisors thinking we're going to have the GDPR. Okay. All right. Anyone thinks it's going to be Data Protection Act with some knobs on, maybe? A much smaller number. Anyone think we can have no legislation at all? Repeal, the kind of extreme UKIP dream? No. Well, there's a surprise. Privacy lawyers not in favour of repealing Data Protection Act. Okay. There was a question from the audience. Yeah, gentleman there.
Yes, and I've been recusing myself from all the votes. My accent. But one sort of question and perhaps observation is it certainly seems you're describing almost a sort of game of negotiating chicken over this, who can hold out the longest before have to start to perform the negotiation. One observation, and I don't know whether this is significant or not, but there's been a lot of conversation about the impact of the uncertainty during this limbo period. From an American perspective, I work with a number of companies who often are at the point of deciding, are we ready to jump across the pond and start to open up business and open up doors in Europe? And it seems to me most of these companies that I work with are now in a situation where if it's uncertain, the default is let's go somewhere else. And a convenient country in terms of language is, of course, Ireland. So they sort of seem like the default winner in the short term in terms of new investment and expansion. Is this an impact or a consideration, or is this sort of a rounding error with regards to the larger economic impact of the uncertainty?
I mean, we've got Paul here from Accounting. So I wonder what your view is on this from the Dublin perspective.
Hold on, Paul.
In general terms, I think politically, I think we would have been very pro-Remain. So, as our closest ally and nearest neighbour, I think the preference would have been for the UK to stay in Europe. Now that it's happened, I think we're thinking, well, there's opportunities here for Dublin as well. There's already a large number of technology companies, around Silicon Dock, as it's called. And I think there's a lot of opportunities there, maybe for Ireland, and we're already seeing that in terms of being contacted by companies in the States that are now looking at alternatives to the UK. I think the one downside, though, is there's such a lack of certainty. And from an Irish perspective, that lack of certainty isn't good for us either, because we're a net exporter to the UK. And then the whole Northern Ireland...
I think everyone is. I think everyone is.
And the other thing I'd say is, so we do see opportunities, but there's challenges as well. We're used to having referendums in Ireland, and we have also had a couple of scenarios where we've been asked to vote again. So we rejected the Nice Treaty, and then 6 months later went back to the polls and accepted it. We rejected the Lisbon Treaty. 6 months later, we went back and accepted it. So don't underestimate the possibility of a second referendum. That's all I'd say. But from an Irish perspective, we do see challenges, but opportunities as well.
Certainly clients are asking at the moment, what should Plan B be? I don't think we've had anyone yet saying, all right, we know what Plan B is, let's implement Plan B, but we've got lots of people asking, what is Plan B? What should Plan B be if Brexit happens? Christopher, I'm not going to come to you yet, because you've had one bite of the cherry. Yes, gentleman down here.
Thank you. Bob Wakes and Langley Ruskin. Although I speak in my own capacity. If the UK went for an EEA-like association with the EC, would we have to pass our own general data protection regulation clone to be adequate, and would we be held up and judged as like an external applicant for adequacy on that basis?
So, Finn, why don't you start with that?
If you went into, so if UK became a member of EFTA, I mean, UK used to be a member of EFTA, founded EFTA actually, then you would be subject to what is called the EFTA Surveillance Authority, which is the Commission, which is basically the enforcer. So from our experience is that they are extremely strict, often more strict than the agencies in the EU. So they sort of replace the agency, as far as I know. I don't know how it is on data protection, how it will be in a regulation, but generally speaking, it will be the EFTA Surveillance Authority who will be the enforcer and looking after whether or not the EU law is being followed. And it's completely implementation. We basically adopt the laws in Norway, in Norwegian, but it just goes through Parliament and it's just stamped. So it's, the simple question is exactly the same, but it will be your own law. That's how it is in Norway.
I mean, I think
so we'd have to have our own law identical or almost identical to the regulation.
Yeah, and especially when it's a regulation, it has to be identical as well. So it's,
Well, I mean, the rules say essentially equivalent. It doesn't say identical. So, but clearly that would be a matter for negotiation with the Commission. And again, it would depend. I suppose a key factor to take into account is, at the moment, there are areas of flexibility within the GDPR, or there will continue to be areas of flexibility within the GDPR, which is open to member states to implement in certain ways. You know, member states can, derogations in Article 23, etc. And it's open to member states to interpret those within reason and within parameters set out, obviously, in the recitals and the rest of the regulation. If the UK, once it has left, wishes to have an adequacy agreement, then one would assume that the Commission will determine whether our regime is adequate or not, and I mean, one reading again is that the Commission could say, well, we're not particularly keen on the way that you have interpreted this particular article in this flexible way. We think you should have interpreted it in this way. And so, in a sense, that is ceding some of the control that the UK might have had in terms of its implementation. Now, I mean, there are other readings. I mean, again, who knows, but whether it would be regarded that the current Data Protection Act with certain modifications and certain strengthenings would be good enough. We just, again, it's too early really to say, but clearly there are lots of considerations there. I think we operate on the basis, certainly now, that the UK government position is that the GDPR will need to come into force in the UK. And then further discussions about adequacy, etc., will be for a later date.
So I think there are two models here we're talking about at the same time, but are slightly different. So one is we're an EEA member, and the EEA membership, the EEA in fact examines every piece of European legislation, and there are some amendments agreed where necessary. So if you look at the EEA treaties, there are the schedules to that have pages and pages and pages and pages and pages of little tiny teeny amendments to European Union legislation so that they can be implemented into the EEA. So what there will not be is an amendment to the GDPR that's affected by the EEA treaties. There's then a question of national implementation once you've settled those little tiny tweaks. But if we're an EEA member, we're going to be adequate. That's the deal. That's part of what being an EEA member will involve. I guess it is technically possible that EEA members will not be under GDPR, but it's inconceivable. The situation, if you are outside...
Is that a Linklaters chart? Is that publicly available?
That is a Linklaters chart. But I think it is also publicly available.
I mean, I think the slides for this session will be available on the website.
So if you step outside the EA, then the question of adequacy arises. You know this better than me, probably. Then the interesting question about is what does adequacy mean? If you ask the Swiss, who are currently in the process of drafting their GDPR equivalent, they're not proposing to take the GDPR and just go ka-ching, ka-ching, cookie cut. Their legislation will be different. It's also the view of Swiss Council I was speaking to yesterday, who's involved in that drafting process, saying it's inconceivable that Switzerland won't be adequate under the GDPR arrangement. So different, but still adequate. That I think is how different, in what form, who knows. Gentleman there. We have time probably for one more question after this.
Thanks. Steve Dickinson from the ICO, just speaking in a personal capacity. I just wondered, my understanding is that if we were to leave the EU but rejoin the EEA, we would probably lose the opt-outs that we've negotiated over the years, which means that a lot of the things that have been derogated back to the UK, we would then they would then be under the European control. So ironically enough, we'd be sort of more subject to European legislation than we would be currently. But it also means that in data protection terms, we would probably then be required to implement the law enforcement directive for domestic policing as well as for the international policing. Do you have any thoughts on that?
Anyone like to comment on that?
It's a reasonable interpretation, I think. Not again, much to be worked through, and the law enforcement directive presents a whole set of additional challenges, not least of which is that, of course, it cross-cuts. So DCMS is the lead, following its move from MOJ, the lead data protection department in the UK, but obviously an awful lot of the law enforcement directive work is Home Office and security agencies focused. So anyway, but yes, it may well become trickier. It will become trickier, I think. Sorry, it's not very clear, but
I think it's probably the result. It's going to be the result of some political settlement. I mean, the EEA treaties, indeed the European Union treaties, are not law in the same way that, you know, this is a room full of many lawyers that think of law. It's a matter of political compromise, and there are, when you dig into it, oodles and oodles of exceptions for European Union members and EEA members. The position of Greenland, some of the French overseas territories, the more you unpick it, the more exceptions you find. So I wouldn't assume that because the EEA works this way today, if the UK joined the EEA, it would work that way tomorrow. It'll be a matter of political negotiation. The challenge there, of course, is time. One final question. Yes, Gail.
Good morning, I'm Gail Crawford from Latham Watkins. I just wanted to get your thoughts about how many sets of DP laws we might end up with, because I think the way we've been talking is perhaps optimistic in that we'll serve Article 50, and at the end of Article 50 we'll have agreed which of these models we'll be in. And given it took 4 years to agree the General Data Protection Regulation, I guess I'm a little more cynical, and I think it's possible at the end of that 2 years we may have agreed the basic terms of exit, like what happens to people who are already in the UK, but we may not have agreed exactly which of these models we're in. So I just wondered what your thoughts were on what would happen then. I think we can probably assume the GDPR will have come in, will then fall away, and I think you probably end up then with some sort of interim mess and then maybe a final mess at the end of that. But just wondered if you'd like to put some bets on when you might be eating your hat again, Richard.
So to be clear, I didn't eat my hat. I won that bet. As you don't know what I'll talk about that afterwards. So at the point of exit, might we have no GDPR? Might we have no solution at all? What do people think about that on the panel?
That wouldn't be the position that the government would want to be in.
And do you think, I mean, because we're just talking about GDPR, but there's thousands and thousands of other laws that fall into this same category. So I don't know how easy this is, but it seems like you might grandfather them all in and then slowly start amending them. And I guess we're lucky with the GDPR that we actually have the ICO and a body that can look at just one law, but for a lot of these, you know, we don't have that position.
I mean, I think the assumption is you would grandfather them, but they would need some amendment, so you couldn't just grandfather the GDPR into UK law because you've got all of the references to the EPB, so you would need to grandfather and tweak, I think, which, again, getting back to the amount of resource you're going to need in order to go through and look at that legislation and make those changes makes this a relatively scary prospect. You know, the other option is it may be that we will have a clear idea about when the GDPR will, we know when the GDPR will start. We might have a clear idea about when we're going to leave. And, I mean, maybe we'd just leave the Data Protection Act in place, apply the GDPR for a little bit, and then let it drop away and then drop back down to the Data Protection Act. Who knows?
Look, I think, sorry, can you have something to add?
No, I mean, just one reflection. I mean, I think that the challenge is also what will happen in 5 years when the UK has not been a part of the decision-making process, the shaping of laws. I mean, there's now the discussion of e-privacy is coming up, and it will be a new law in a few years. And this is what we see from a Norwegian perspective is time and time again, we're off the ball. We're not understanding what's going on, and we come in too late, and then it's adopted, and then we just have to accept it. I would be more worried about if in 5 to 10 years, if you're not a member, the direction that the EU is going and the lack of influence on the laws in general. I know it's a bit on the side of what you asked, but that is where I've seen 20 years of being outside the European Union after we got the EEA. We're just scrambling to influence the most important pieces of legislation, and the rest is just coming. And we're just implementing and rubber stamping, and except in the field of agriculture. But we still have to implement all the food safety standards anyway. So, yeah.
There was one final thought, actually, we haven't talked about that we wanted to flag, which is that people have asked this separately about lead regulatory authority under the GDPR, whether it is possible for a non-EU authority to be the lead regulator for GDPR purposes. And there's quite an interesting debate about that currently going on in Switzerland. There's plenty of reason to think that's quite a good idea, both from an EU perspective and a Swiss perspective. If you're an EU DPA with a limited budget and not a lot of time on your hands, do you fancy regulating the large range of Swiss corporates, or would you rather delegate that responsibility to the Swiss DPA instead in a kind of reciprocal arrangement? There's quite a lot of legs in that conversation, it seems to me, and you can see how a similar arrangement might apply for the UK. And there's some quite nice precedent in relation to MiFID and the concept of equivalence there. So I wouldn't necessarily assume, even some of the models lower down this chart, that the ICO is not going to have a role as a lead regulatory authority, because there is, in the cold, hard light of days, a lot of DPAs will be enthusiastic not to be regulating all of the UK's large multinational corporates.